Picture the heavy, almost suffocatingly humid air of a South Carolina courtroom. You can feel the tension just radiating off the wood-paneled walls.
Oh, absolutely. The atmosphere in those rooms is thick.
Right. And there's this crushing, inescapable weight of a double murder conviction hanging over the room. A prominent former lawyer, a sign of this local legal dynasty, has just been condemned for the unimaginable.
The 2021 murders of his own wife, Maggie, and his son, Paul.
Exactly. The gavel falls, and the story is just, well, it's supposed to be over.
Yeah, I mean, that gavel strike is supposed to function as the ultimate period at the end of a very long, very dark sentence. It represents absolute finality. Justice served right under the intense glare of the public eye.
But then imagine the sudden, shocking crack of a higher court's gavel overturning it all, just tearing up that final sentence. Today, we are taking you on a deep dive into an absolute bombshell.
The reversal of Alex Murdaugh's murder conviction.
Yeah, and we aren't just looking at the headlines you might have, scrolled past online. We are going straight into an exclusive inside access interview with his defense attorney, Dick Harpootlian.
Which was captured right after this staggering ruling came down. It's a moment that completely rewired one of the most high-profile legal sagas of the last decade.
It really did.
When a conviction of this magnitude gets tossed out by the South Carolina Supreme Court, it forces us to look behind the curtain, to question the actual mechanics of how a verdict is reached.
So our mission for you today is to reconstruct exactly how this happened. We're going to unpack the bizarre misconduct that broke this case wide open. We will dissect the crumbling physical evidence, and we'll explore the intense, high-stakes legal chess match of the upcoming second trial.
It's going to be wild.
Okay, let's unpack this. Because the reason for this reversal wasn't, it wasn't what you might expect from watching courtroom dramas.
No, not at all.
Yeah.
I mean, when we hear about overturned convictions, our minds immediately go to the classic true crime tropes, right?
Like a surprise witness coming out of the woodwork.
Exactly. Or a new, undeniable DNA match. Some hidden forensic clue that definitively exonerates the defendant.
But there was no secret DNA here. It was an inside job.
Yeah, a completely compromised system from within. The core of the South Carolina Supreme Court's ruling, this 27-page ruling, centered entirely on the actions of the court clerk in the original trial.
A woman named Becky Hill.
Right. And the details of her confession outline an illegal and improper influence over the very people trusted to decide Murdaugh's fate, the jury.
And she didn't just accidentally slip up in the hallway either. We are talking about a systemic, deliberate campaign of interference here.
It's staggering. The defense laid out how the clerk was lying under oath. She was taking sealed, highly sensitive crime scene photos and showing them to reporters.
Which is insane on its own.
It is. But most devastatingly, she was relentlessly lobbying the jury. To understand the gravity of that, you really have to look at the psychology of a jury.
Right, because they're totally isolated.
Exactly. Jurors are pulled out of their normal lives, placed in this intimidating environment, and instructed on complex law. The clerk of court is basically their shepherd.
She tells them when to stand, when to sit, when to eat.
Yeah, when to go. They view her as an extension of the judge. So when that person is whispering in their ears, telling them, not to believe Alex Murdaugh when he testifies.
Actively pushing them to find him guilty?
Right. And even trying to remove jurors who express doubt. It is incredibly coercive.
I mean, you hear that and you just have to stop and ask what the motive could possibly be. Why does a court clerk risk her career, her freedom, and the integrity of a massive double murder trial?
Well, it all comes down to a motive that is just remarkably modern. She was writing a book.
A book?
Yeah. She wanted to monetize the tragedy. She knew, very calculatingly, that a guilty verdict would sell more copies.
Wow.
I mean, a convicted murderer makes for a better, more lucrative ending to a true crime book than a messy mistrial,
Right.
Or a confusing acquittal.
That is just, it's like a referee not just betting his life savings on the Super Bowl that he's officiating, but actively running onto the field and tackling the quarterback.
That's a great analogy.
You are supposed to be the neutral guardian of the game. If you are listening to this, you might be wondering how a grueling, emotionally draining 6-week trial resulted in a verdict in just 3 hours.
Which is incredibly fast for a trial of that magnitude.
Right. And according to Harpootlian, this completely explains it.
Yeah, from the defense's perspective, this jury was essentially fixed. The Sixth Amendment guarantees the right to a fair trial based solely on the facts presented in open court.
Just the facts.
Exactly. If you have an authority figure lobbying the jury at every smoke break and lunch hour, you don't have a deliberation. You have a guided conclusion.
So the conviction is tossed, The slate is wiped clean. But that logically forces us to pivot to the consequences here.
Right, the fallout.
If the jury was compromised by the clerk, what does that mean for the actual evidence the state presented? Because, book deal or no book deal, there was a 6-week trial.
There was mountains of evidence.
Exactly.
And this is where the Supreme Court's ruling becomes this fascinating roadmap for the second trial. As Harpootlian pointed out, the court reversed the conviction solely based on Becky Hill's conduct.
They didn't even need to look at the other stuff.
Right. They explicitly stated they didn't legally need to find additional grounds to toss the verdict. But they couldn't resist leaving a breadcrumb trail for the defense.
Ah, the famous footnote. Embedded in this long explanation about the various evidentiary issues is a massive warning to the next trial judge.
Yeah. The Supreme Court essentially cautioned that the state went way too far with the financial crimes testimony. Usually in a court of law, you cannot introduce evidence that someone is a bad person or a thief just to prove they are a murderer.
Right, that's character assassination.
Exactly. It's barred by what's known as Rule 404B.
But the state got it admitted in the first trial anyway.
They did, yeah, by arguing this very specific loophole. They claimed the financial crimes provided the motive.
Because his world was crashing down.
Right. The prosecution's theory was that Murdaugh's decades of stealing millions from clients were about to be exposed. So, to buy time and generate sympathy, he slaughtered his wife and son.
And the judge bought that theory and just let all the financial fraud evidence in.
Yep.
So the Supreme Court's footnote is essentially telling the next judge, don't buy that excuse so easily next time.
Okay.
But I have to push back here, speaking for everyone listening who followed this trial excessively. Murdaugh admitted to lying.
He did.
He admitted to the police that he lied about being at the dog kennels the night his wife and son were slaughtered. He blamed his lies on paranoia from taking oxycodone.
Right, the drug addiction defense.
Yeah, so isn't a confessed liar, a disbarred lawyer, and an admitted financial fraudster just a hop, skip, and a jump away from being a family annihilator?
I mean, it is the most natural leap in human psychology to make. You see a bad person doing bad things, and you just assume they are capable of the ultimate bad thing.
Right.
But Harpootlian, drawing on his background, trying 15 death penalty cases, methodically breaks down why that is a fatal flaw in a court of law.
How so?
Lying to the police because you feel like a suspect or because you have pills in your pocket and you're deeply paranoid, that does not prove murder beyond a reasonable doubt.
Being a liar doesn't automatically pull the trigger.
Exactly. And this is where the defense focuses all their energy for round two. The stunning, glaring lack of forensic ties. Harpootlian points out there were no fingerprints connecting him to the weapons.
None.
There was no DNA, there was no video, there was no confession to the murders.
So if the state's whole case rested on showing what a terrible, fraudulent person he was, just to distract the jury from the lack of physical evidence, how does the defense counter that in the sequel? I mean, they can't just erase the fact that he stole millions.
No, they can't. So they counter it with a brilliant, almost paradoxical legal strategy. Murdaugh is willing to plead guilty to the financial crimes.
Wait, really? He is just going to preemptively admit to the massive financial fraud?
Yeah, because he knows he is never getting out of jail anyway. He will spend the rest of his life in prison for stealing that money, regardless of the murder trial outcome.
Oh, I see.
By pleading guilty, he takes all the heat off those charges in the murder trial. If the state tries to bring up his thefts to prove motive, the defense can turn to the jury and say, yes, he stole the money, he admitted it, and he is already serving a life sentence for it.
Wow. It completely neutralizes the state's ability to use his financial misdeeds as a smokescreen for murder. It forces the new jury to look only at the physical evidence of the killings.
Or, more accurately, the utter lack thereof.
Right, which logically brings us to the blood spatter. Because the state didn't just have financial crimes, they leaked to the entire world that they had hard physical proof.
Right, and this is the moment that truly exposes the fragility of the state's physical case. Let's look at the mechanics of why this evidence was so critical.
Let me set the scene for you. It's late 2022, around Thanksgiving. The defense team is frantically preparing for the biggest trial of their lives, which is less than 90 days away.
The clock is ticking.
Yeah, and outside their office, the media, the true crime bloggers, the national news, everyone is buzzing with this devastating leak. Reports are everywhere that Alex Murdaugh's T-shirt from the night of the murders had high-velocity blood spatter on it.
Which is huge. For context, high-velocity blood spatter is that fine mist of blood that lands on a shooter when they fire a weapon at very close range.
It's basically the smoking gun.
It is the holy grail of forensic evidence for a prosecution. The physics of it are undeniable. If he has their blood misted on his shirt, he pulled the trigger. There is just no innocent explanation for being covered in a high-velocity mist of the victim's blood.
So the defense is staring down the barrel of this supposedly undeniable physical evidence. But then enter Holly Miller. She is a defense paralegal tasked with digging through millions, literally millions of pages of discovery handed over by the state.
The sheer volume of data in a modern trial is paralyzing. Holly Miller wasn't just looking for a needle in a haystack. She was looking through 1 million receipts from 1,000 different grocery stores trying to find one specific barcode.
That's a great way to put it.
And the state was likely banking on the fact that human eyes would just glaze over before the 90-day clock ran out.
Here's where it gets really interesting. She spots a witness name on a file that she has never seen before. She opens this obscure electronic file, and inside is a hidden report from SLED.
The State Law Enforcement Division.
Right. It's an official forensic lab report on that exact T-shirt. And the conclusion, the spatter on the shirt was not human blood.
It was a devastating discovery for the prosecution. I mean, this official lab report directly contradicted the entire narrative the state had been leaking to the public for months.
And their own expert.
Exactly. It directly contradicted the expert from Oklahoma that the state had lined up, who was totally prepared to testify that the spatter was indeed human blood consistent with a shotgun blast.
Wait, if Holly found a state-sanctioned report saying it wasn't human blood, that means the prosecution had this exonerating evidence the entire time they were leaking the bloody shirt narrative to the press. That borders on prosecutorial misconduct. How did the state justify that when the defense finally cornered them and demanded to examine the shirt themselves?
Well, the state suddenly claimed the shirt had been destroyed during their testing.
Destroyed.
Yeah.
Just accidentally ruined 90 days before the trial of the century.
Convenient, right?
If you're listening to this and thinking, evidence doesn't just accidentally get destroyed when it's the centerpiece of a double murder case. Well, you're having the exact same thought the defense team did.
And that expert from Oklahoma who was going to testify about the human blood spatter, he completely evaporated.
It's amazing how quickly an expert loses their calendar availability when the defense pulls out a lab report proving them wrong. Poof, gone.
The entire centerpiece of their physical evidence just vanished into thin air. Harpootlian believes this vanishing shirt is the specific mechanism that forced the state to lean so heavily on the financial crimes in the first trial.
Because they had nothing else.
Right. Without the blood spatter, they had nothing to connect him forensically. No eyewitnesses, no tape, just a guy who demonstrably lied about his whereabouts.
So the state has lost their physical evidence, and the defense has neutralized the financial motive by pleading guilty to those crimes. But none of that legal maneuvering matters if you can't find 12 people who haven't already made up their minds.
Which is almost impossible now.
Exactly. How do you even seat a jury in a case this viral?
That is the logistical nightmare that will define the second trial. The first step is getting a new judge appointed to oversee everything. Once that happens, Harpootlian plans to file pretrial motions almost immediately to change the venue.
They have to move it out of Colleton County, right, where the first trial was a literal circus.
Oh, absolutely. But they can't just moot it anywhere.
Wait, why not? Can't they just take it to a massive, bustling city like Charleston to find people who haven't heard of the local legal dynasty?
No, the law entitles them to a jury pool from a demographically similar area. Harpootlian notes they need a county that matches Colleton's makeup, which is roughly 35% African-American and primarily rural.
Why does that specific demographic matter so much to the defense?
Well, it comes down to rural versus urban jury psychology. In a rural, historically entrenched county, a dynastic family like the Murdaughs carries an immense amount of historical baggage.
That makes sense.
Some people revere them, while some people deeply resent their generational wealth and power. You need a jury pool that understands the cultural context of the Lowcountry, but isn't personally infected by decades of local gossip.
Finding a county that meets that demographic criteria, where the jury pool hasn't also been saturated by the national media coverage, that is going to be incredibly difficult.
Very. Which makes jury selection the only battle that actually matters here. That's why Harpootlian is demanding attorney-conducted voir dire.
Explain the psychology behind that, because normally the judge just asks the questions.
Right. In South Carolina, typically, only the judge questions the prospective jurors. A judge in a black robe sits high on a bench and asks a room of citizens, "Can you be fair and impartial?"
And human nature dictates that everyone politely nods and says, "Yes, Your Honor."
Exactly. Nobody wants to stand up in front of a judge and admit they are biased.
No way.
So attorney-conducted voir dire changes the entire psychological dynamic. It allows the lawyers themselves to deeply interrogate the potential jurors. It's usually reserved for death penalty cases.
So it's much more intense.
Very. An attorney won't just ask if you can be fair. They will ask what podcasts you listen to, what news stations you watch, what you posted on Facebook 3 years ago.
Wow.
Given the unprecedented taint on this case, from the clerk's tampering and the media circus, the defense will fight tooth and nail for the right to ask these specific, piercing questions to ensure they don't get another compromised jury.
Okay, so let's say they miraculously get that perfect, impartial jury. There are still massive wild cards waiting to be played. The biggest one, will Alex Murdaugh take the stand and testify again?
Honestly, taking the stand is the ultimate liability. He is a convicted felon and an admitted liar. When he takes the stand, he opens himself up to grueling cross-examination.
But he is also a disbarred lawyer.
Exactly. Harpootlian made it very clear that this decision rests entirely with Murdaugh. The defense team can advise him against it, but Murdaugh understands the legal mechanisms better than a typical client.
He could literally decide the morning of the trial whether he wants to face the prosecution again.
He could.
The suspense of that alone is intense. But there is an even bigger wild card that Harpootlian dropped. The defense claims they have received new information, concrete information, pointing to alternate suspects for the murders of Maggie and Paul.
And this is where the reversal of the conviction fundamentally changes the power dynamic of the entire case. Before, the defense was merely playing defense.
Right, they were reacting to the state's evidence and trying to poke holes in it.
Yeah, but now that the conviction is overturned and the legal process has officially restarted, the defense regains subpoena power.
So they can go on the offensive. What does subpoena power actually let them do in this context?
It allows them to legally force third parties to hand over data. They can compel phone companies to hand over cellular records and tower pings that the state might have ignored.
They can dig up their own evidence.
Exactly. They can compel reluctant witnesses to sit for depositions under oath. They can launch a full, legally backed investigation into these alternate theories.
Something they didn't have the time or the jurisdictional authority to fully execute the first time around when they were racing against that 90-day clock.
Right.
The hunter becomes the hunted. It completely flips the script on the prosecution.
And the state is securely locked into a very uncomfortable position right now. The prosecution's witnesses have already testified under oath on the record in the first trial.
Oh, that's huge. The defense possesses the transcripts of exactly what they said.
Yeah. If any state witness tries to change their story or adapt their testimony to counter the new defense strategy, Harpootlian can use those first trial transcripts to impeach them in front of the new jury immediately.
He can basically hold their own words hostage.
The state's playbook is wide open for the world to read, while the defense is holding their new alternate suspect cards completely hidden.
It is going to be an unbelievable legal battle to watch unfold. To look back at the journey of this deep dive, we started with a high-profile, seemingly ironclad conviction that everyone assumed was the final chapter.
But when you pull back the layers of this case, you find a verdict undone by the greed of a court clerk looking for a book deal.
Yeah, you find a prosecution that was forced to pivot to financial crimes because their physical evidence, that infamous bloody shirt, miraculously vanished when a paralegal found a hidden report proving it was useless.
It's wild. And now you have a defense team armed with renewed subpoena power, a neutralized financial narrative, and a mandate to find a truly impartial jury in a world obsessed with the case.
If you connect this to the bigger picture, it serves as a stark, almost terrifying reminder of the fragility of the justice system.
It really does. We place so much inherent faith in the structure. We trust the judge, we trust the jury, we trust the forensic evidence.
Right.
But this specific case proves that the actions of one unseen person whispering in the background of a jury room can completely derail the search for the truth. It reminds us that justice is only as blind as the people administering it on any given Tuesday.
Which leaves you with one final unsettling thought to carry with you as we wrap this up. In an era where true crime isn't just evening news, but a massive, multi-billion-dollar entertainment industry, did the public's insatiable hunger for this story inadvertently destroy the justice we were all watching to see served?
That's a chilling thought.
It was that very hunger, that relentless demand for a bestseller and a shocking true crime ending that motivated a court clerk to tamper with the jury in the first place. You have to wonder as you picture that heavy, humid courtroom and hear the final crack of the gavel. Are we just the audience? Or did our demand for entertainment make us a part of the crime?